Hello and welcome to another Paddocks Club video tutorial. Today I'm going to be talking to you about the maximum rate of interest that can be set on arrear levies. And we're going to take you through a case which is quite interesting, and it unpacks the principles which are applicable to this issue. So first of all, let's look at Prescribed Management Rule 31.6, and this rule states that the trustee shall be entitled to charge interest on arrear amounts at such rate as they may from time to time determine. But there's no guidance in this rule as to the rate of interest that can be set by trustees. Now we know that in terms of section 35.3 of the Act, all rules must be reasonable. So it follows that if a rate of interest is set by the trustees, that interest rate must be reasonable. But what is a reasonable rate? Well, according to Professor Graham Paddock, the rate cannot exceed the rate set in the Prescribed Rate of Interest Act, which is currently set at 15.5%. This view is confirmed in Body Corporate Linwood Gardens versus Mureli Yegi and another. In this case, the court examined the statement that interest cannot exceed the rate set in the Prescribed Rate of Interest Act, which is currently 15.5%. Section 1.1 of this Act states that if the debt bears interest and the rate of interest is not governed by any other law or agreement, such interest will be calculated at the prescribed rate. In the case of Linwood Gardens, it was decided at the AGM to direct the trustees to set the rate of interest on arrear contributions to 10% per month. The court held that the obligation to pay interest at a rate of 10% per month was created by agreement by the sectional owners, and for that reason the Prescribed Rate of Interest Act did not apply. This decision hinged on the fact that the decision about the rate of interest was taken at the AGM, so it was an agreement between the owners, and it stated that the Prescribed Rate of Interest Act is still applicable if the rate of interest is set by the trustees, that is not by agreement between the owners. So just to go back to that section 1.1 of the Prescribed Rate of Interest Act, it states that if the debt bears interest and the rate of interest is not governed by any other law or agreement, then the Prescribed Rate of Interest Act applies. But when you've got a situation with the AGM or an SGM and owners by agreement setting an interest rate, then the Prescribed Interest Rate Act doesn't apply, and the owners can decide what their maximum rate is. So let me just summarize that for you. The court found that the Prescribed Rate of Interest Act would apply if there's no agreement between owners as to the rate of interest. So this is the case when the trustees themselves get together, set the rate of interest, there's no agreement as to the interest rate by the owners, and so because there's no agreement, the Prescribed Rate of Interest Act applies, and 15.5% per month is the maximum that the trustees are allowed to set as the rate for interest on arrear levies. Now, if the trustees are not setting this rate by themselves and the owners come together and agree to a rate either at an AGM or an SGM, then the Prescribed Rate of Interest Act does not apply and the owners are entitled to set their rate of interest at a rate that they agree. So the court also made a few further remarks which I just think are interesting for us to note, and that is they looked at the case of Standard Bank of South Africa versus Onionate Investments, where it was held that compounding or capitalization of interest is not permissible because to allow for such a practice would be an easy method of avoiding the induplum rule, which is a rule that states that a creditor can only recover maximum interest up to the amount of the capital debt. So what that means is, for example, if say a person's in arrears for 20,000 Rand, interest can run up until it reaches 20,000 Rand. But as soon as the interest goes over 20,000, it's no longer collectible. So a creditor can only recover a maximum amount of interest that equals the amount of the capital debt. So we can't get a situation where a creditor is recovering 30,000 Rand of interest on a 20,000 Rand debt. No, the creditor can only recover a maximum of 20,000 Rand because the debt is 20,000 Rand in terms of the induplum rule. So just to go back to the Linwood Gardens case, the court held finally that interest must be charged at the rate set by agreement of the sectional owners, which was 10%, subject to the induplum rule. So I found that quite interesting. I hope that you've learned something today. If you have any questions, please post them on the discussion forum and we'll answer you there. Thank you.